Hello everyone, this is Anisha Sharma, intern at LEXCLIQ and Company. I'm also a fourth year student at Modi University. My previous video was related to the authorities that are established under the Industrial Dispute Act of 1947. Earlier, I have discussed section 5 that talks about the conciliation board, the works committee, and the conciliation officer. And in the present video, I'll be dealing with the court of inquiry that is established under section 6 of the act. So, a disclaimer for the video. This video does not solicitate or promote any kind of advertisement for the firm. It is only for educational purpose and it is in accordance with the rules as established by the Bar Council of India. Coming on the video, the court of inquiry, if any occasion arises, and the state government can initiate a court of inquiry. This court of inquiry was to find out matters concerned with or with relevant to any industrial dispute where a court consists of 2 or more members. One of them shall be appointed as a chairman. A court of inquiry looks into only matters which are referred by government and submits its report to the government ordinarily within period from the date of reference. Adjudication first is the labor court. So the appropriate government is empowered to constitute one or more labor courts. Its functioning and adjudication of industrial disputes relating to matters specified in second schedule. And second is the industrial tribunal. So the appropriate government may by notification in its official gazette constitute one or more industrial tribunals for the adjudication of industrial disputes relating to any matter, whether specified in the second or third schedule, and for performing such other functions as assigned to them under this act. According to section 10 subsection 2, when parties in any industrial dispute apply for the government to refer dispute to the industrial tribunal, and if the government is satisfied, it can make reference to the industrial tribunal. The government can make reference to the industrial tribunal. And according to section 10 subsection 6, no labor court or tribunal should have jurisdiction to adjudicate upon any matter which is under adjudication before the national tribunal. So no other labor courts or tribunal will have jurisdiction in that case. A tribunal consists of one person only for appointment of the presiding officer of a tribunal. He is or have been a judge of the High Court, or he has for a period of not less than 3 years been a district judge or an additional district judge, or he is or has been a deputy chief labor commissioner of the center or a joint commissioner of the state labor department, having a degree in law and an experience of 7 years in the labor department. Third point is the national tribunal. So the central government may by notification in its official gazette constitute one or more national industrial tribunal. It may function as the adjudication of industrial disputes which involve question of national importance or affecting the interest of 2 or more states. According to section 10 1A, dispute involve any question of national importance or is of such a nature that industrial establishment situated in one or more states would be affected. In that case, the matter would go to the national tribunal. According to section 10 subsection 2, when parties in the industrial dispute apply to the government to refer dispute to of the national importance, when parties refer the dispute to the national tribunal, and if the government satisfies, it shall make reference to the national tribunal. The central government shall appoint a national tribunal consisting of one person only, and the qualifications is that the person should be appointed a president of the national tribunal must be or have been a sitting judge, or must be or have been a judge in the high court, or must have held the office of the chairman or any other member in the labor appellate tribunal for a period of not less than 2 years. Thank you.